For decades, Republicans in Texas have been making it harder for Texans to vote. They know that their best chance to hold on to power is to limit access to the ballot. Because when more people vote, our democracy is strengthened. And when more Texans vote, Democrats win. Now, Republicans are exploiting a global health crisis to keep people from exercising their right to vote. And we won't let them get away with it. Texas Democrats will never stop fighting to expand and protect access to the ballot. In order to turn Texas blue in November, we're committed to registering and engaging a new electorate that reflects the diversity of our great state. But if we're going to be able to win, all eligible voters in Texas must be able to cast the ballot and have that vote count. When it comes to voter protection, we've taken to the courts to challenge Republican voter suppression efforts. We fought Republicans' discriminatory voter ID law and won, and beat David Whitley when he corruptly tried to purge the voter rolls. We've also launched a year-round voter protection hotline, which is helping voters navigate the voting process from beginning to end. In order to get more Texans registered to vote, we've undertaken the most expansive voter registration program in our party's history. We recently launched registertexas.com to ensure that all Texans can register to vote from the safety of their own homes. We're also mailing hundreds of thousands of voter registration applications to unregistered voters across the state. Democracy works better when more people vote. Learn more about our voter expansion and voter protection. For decades, Republicans...
Donald Trump can't win the White House without Texas. And that means we have to fight like the future of our state and our country depends on it, because it does. Our party and the democratic movement we have built is powered by the hundreds of thousands of Texas Democrats who graciously contribute to our efforts. Over the years, thanks to individual donations of $3, $7, and $10, we have built a democratic infrastructure capable of turning Texas blue up and down the ballot. The support we've received from donors is incredible. These grassroots contributions are the driving force behind our work and our victories. Now we're headed into the most important election of our lifetimes, and we can't take our foot off the gas. We will never stop working to create opportunities for hardworking Texans. We're fighting for strong neighborhood schools, higher incomes for working families, quality healthcare, and an economy that works for everyone. By contributing just $7, you will propel our movement forward and bring us that much closer to flipping Texas. Together, we can win this election. Together, we can change the course of history.
Registration week, where we are aiming to contact up to 1 million Texans who are unregistered to vote in hopes of getting them registered for the 2020 election. This could be historic. This could completely change the electorate. So if you're interested in talking more about that, we will connect afterwards. But we also were in court today with our general counsel here, Chad Dunn. He's going to tell you a little bit about how that went. And what we'll do afterwards is do a question and answer section. To ask a question, type it into the messaging box, and we'll get to the questions first come, first serve. So again, to ask a question, type it into the chat box, and we will get to them first come, first serve. With that being said, I will kick this over to Chad Dunn. Chad?
Good afternoon, everyone. Nice to see some friendly faces here. I, as you know, just gave an argument to the Fifth Circuit on our case involving voting by mail in November. The central case or claim that we're making is the state of Texas offers vote by mail to individuals over the age of 65 without excuse, but everybody under the age of 65 is limited by some very excuses, such as being disabled or injured or out of the county during when voting's taking place. So the district court had ordered the state to comply with the 26th Amendment and provide vote by mail to every citizen regardless of age. And that's been stayed temporarily while the Fifth Circuit takes up the case. That was the purpose of the arguments today. The judges on the panel were Judge Stewart, Judge King, and Judge Southwick. Now, voting by mail is not controversial in 45 other states. And in fact, what Texas offers, President Trump agrees with. He said routinely that he's fine with absentee voting as long as the person has to make a request and their signature match and the other things. All that would stay the same in Texas. There's no dispute among at least the presidential candidates on the matter of whether or not absentee voting ought to be available at large. Texas insists that it ought to be one or just a handful of states that limit it to certain people based on their age. The 26th Amendment was adopted in 1971 for the purpose of prohibiting denial or abridgment of the right to vote on the basis of age. And so we've asked the court today to enforce that constitutional amendment in time for this next presidential election, especially as these pandemic circumstances continue. That's the case in a nutshell. Obi, should we take questions?
Yeah, definitely. If you have a question, type it into the question and answer box and we'll get to it as soon as possible. Okay, first question is from John Moritz. He says, is it correct that if you prevail under the 26th Amendment, vote by mail will last far beyond this pandemic?
Well, we have two claims under the 26th Amendment. One is what's called a facial challenge, which means the restrictions Texas have by age are unconstitutional under every and all circumstances. So whether or not there was a pandemic, it would be unconstitutional. We've also argued that as applied, that under the current pandemic circumstances, the election rules cannot tolerate a situation where some people get to vote safely from home by mail, whereas others have to go vote in person. Now, the injunction that Judge Beery in San Antonio entered was on what's called the as applied challenge. So the injunction he entered only extends as long as the pandemic circumstances extend. Ultimately, whether or not the age restriction can continue after the pandemic will be a matter taken up later at trial. But there's no question our argument is, outside of the pandemic, this is unconstitutional. I'll give you some good examples. We hear from all the time, truckers, offshore workers that can't predict when and where they're going to be to pick up mail or be in and out of the county to vote in person. And they are often disadvantaged by not be able to vote by mail just simply because of their age. So there are real harms under this statute, even outside the pandemic. But right now, it's critically important we get relief so that all voters have an equal right to vote in this next presidential election.
Great. Next question comes from Taylor Goldenstein of the Houston Chronicle. She asks, can you expand on why the state is saying the appellate court doesn't have the jurisdiction and why you disagree?
Well, the state seems to argue that the Secretary of State has no authority over election rules and that this is really all just a county matter. Now, we've sued Travis County and Bexar County election administrators, so even were the court to determine that it's a county matter, those counties would be ordered to comply with the Constitution. And I feel confident the rest of the counties would get the message as to what the law was going to be. But, for those of you who saw the news just over the last 72 hours with the Secretary of State trying to manage the affairs of the Harris County Elections Department, know that the Secretary of State does have a role to play in elections in Texas. The Election Code, Chapter 31, provides the secretary certain authorities over elections. So, we think it's a non-starter of an argument. The Fifth Circuit's rejected it more times than I can count. But that's essentially their argument. And I think that's why it didn't play much of a role during the arguments today, just because there is very little support for it.
Great. And remember to ask a question, type it into the question box, and we'll get to them on a first come, first served basis. Okay, next question is, what is the timeline for a decision, and do you think this will go to the Supreme Court and get appealed if this decision does not go in the way of the state?
Well, I think that the state, as the state pointed out, the deadline to submit an application to vote by mail is October 23rd. So obviously we need resolution of this matter in advance of that. Our position is the sooner the better. The sooner the voters are able to learn about their rights and exercise them, the better it is for all of us. The court decides at what speed it wants to handle its business. It can decide to rule this week, and it could wait weeks or months to get its ruling out the door. So I think that ultimately, however that turns out, you can expect, whether it's the state or us, who might be dissatisfied with it, to go and seek further review. I mean, when it comes down to the constitutional rights of voting during a presidential election, I don't think anybody's surprised that the parties are going to press the case as long as they need to get finality.
Great. Next question is from KPRC. If you prevail, how quickly could you get mail-in ballots, and how could you assure people their ballots will be received in time and counted? How will you make sure that only those with if you prevail, how quickly could you get mail-in ballots, and how can you assure people their ballots will be received and counted?
So mail ballots, don't begin to go out until September 19th, and often it's on a rolling basis. The county sends out mail ballots as they get applications. Like I said, all the way up to October 23rd, you can submit an application for a mail ballot. So I'm confident that the counties in the state can deal with the increase in mail voting. A number of the urban counties, which would presumably be the ones that would be most taxed by this change, have already moved forward with having the equipment and personnel and dollars in place to be ready to adjust for the change. And in fact, the counties argued, every county that filed a brief with the Fifth Circuit argued that not only do they agree with our position on this case, but that they need this solution because they've got to somehow increase the demand on in-person voting, and voting by mail is the way to do that. That's why we're seeing nearly every other state go to this. I mean, even South Carolina during the summer passed its legislature, which is largely Republican, passed a bill extending vote by mail for people by reason of a COVID excuse. So, Texas is really the outlier here. And so, our system is set up, it's early enough to get this process done, and the Constitution requires it. And as I said in the argument, we don't have constitutional rights unless we practice them. And we don't have voting rights unless we're practicing them in presidential elections. And so that's what this case is asking the court to ensure.
Great. Next question is, how confident are you that the court will rule in your favor?
Well, look, I've been doing this long enough to know that you can tell about as much from an oral argument as to how the case is going to come out as you can tell about somebody's cards by looking at the back of them. So I'm not going to give any sort of guesses at how this sorts out. I will say that the legal argument is one of the strongest I've seen in a voting case on our side. I mean, the constitutional text is crystal clear. There's an unbroken line of cases going back for decades saying that you cannot give different voting rights for people based on age and different methods to vote. And even before then, the 14th Amendment claims that we talked about a lot at the argument that existed before the 26th Amendment was adopted, those cases found that you can't provide one voting method for one person and another for another. But so I think the argument's very strong, but ultimately that's why they're the federal judges, and they're going to make a decision. And when we see that, then the parties will do what's necessary to make sure this is fully ferreted out by the courts in advance of November.
Great. Next question is, if Texas absentee voting rules have been so clearly unconstitutional, why did the Texas Democratic Party not sue to change them until after the pandemic began?
Well, our client, Joseph Casino, is 20 years old, so he got to it just as soon as he was eligible. But, the John Maynard Keynes has the economist has a famous quote, "When the facts change, I change my mind." And the reality is the pandemic circumstances that are going on right now made everybody focus on vote by mail. That's why you see all these other states that never offered it at all, except for military and overseas, are moving towards they are creating vote by mail systems. So, I can't speak to predecessor lawyers over the last several decades and why they didn't pursue this case. There's been a whole lot of voting rights litigation in Texas going all the way back to the white primaries in the 1920s. So I can't answer that, but I do know that our clients got to it just as soon as they realized what harm it was going to cause them.
Great. Next question is from Bob Garrett at the Dallas Morning News. If you lose on the 26th Amendment, could you go back to Beerbury and argue for COVID as a disability?
Well, the matter of whether or not COVID fits within the disability or injury provision under state law is resolved by the Texas Supreme Court case. So federal courts can't tell state courts how to interpret state laws. So what the Texas Supreme Court said about disability and injury is set. That's decided. So no, I don't believe that Judge Beery can opine further on that.
Great. Remember, if you have any more questions, type them into the chat box and we will get to them on a first come, first served basis. Okay, next question is, do you think this fight is going to go all the way up to the Supreme Court? And if you lose this case, what happens next?
Well, I mean, it's, as you're aware, it's been up to the Supreme Court in advance of the primary runoff. So, it doesn't surprise me when important constitutional questions find themselves presented to the high court. I will say that, we have our petition for writ of certiorari on file at the U.S. Supreme Court now. It's scheduled to be conferenced by the justices at the end of September. I won't presume, but I would normally expect that we would have a ruling from today's proceeding by then. So, and when you say, is it going to be before the Supreme Court? It's there already. They may decide to take it up. They may not. Obviously, that's their decision making. But how the court rules here will no doubt inform how the Supreme Court views our pending cert petition.
Great. We have time only for a couple more questions. Next one is from Bob Garrett again. He says, what can Beery opine on? O-P-I-N-E on. If you lose on the 26th Amendment, what can he give an opinion on?
Well, a lot will depend on timing. We can return to the district court and press our other claims. There were claims made under the Voting Rights Act and under the Equal Protection Clause, required development of facts in advance in November. So, that's always a possibility. There could be additional action on that, but it's premature to know we're on, let's call it step 35 and that would be step 55. So it's premature to know exactly what would happen then. But for now, this is a 26th Amendment case.
Great. And then Taylor Goldenstein of the Houston Chronicle asks, how high of a risk do you think voters run in requesting a mail-in ballot using the disability excuse, COVID in combination with other health issues? And what are the odds they face prosecution?
Well, I'm not in charge of prosecuting voters, and if I was, I wouldn't have been going around like the Attorney General's office has been with memoranda on the subject up until now. People are doing the best they can. This notion that there are a whole bunch of voters out there trying to cheat the system and stuff the ballot box is just false. Every opportunity the state's been given to prove that in court, which is at least 4 or 5 that I've been present for, it's got no evidence for it. There's very little fraud on vote by mail, and there's even less fraud on in-person voting. And what does exist gets caught and it's dealt with. And, most often when it's found, it's people who just didn't know the rules, that made a mistake. But when it comes to the decision to prosecute voters, our state constitution rests that decision in local district attorneys and county attorneys. And, the standard that the Texas Supreme Court has laid down makes it up to the voters' decision to make a determination. It gives some guidelines, but by no means a hard and fast rule. It seems very unlikely to me that somebody could be successful at prosecuting an individual under that statute. But look, as I mentioned, going all the way back, to the 1920s, the state has at times tried to make it harder and more difficult for certain of its citizens to vote. And if that happens, there's going to be plenty of lawyers and politicians, legislators, government officials ready to step up and protect the voter.
Great. We have time for one more question. If anyone has a question, please type it in now. Okay, last question is, based on today's arguments, do you feel optimistic or pessimistic that Texans will be able to vote by mail this election by November?
Well, as I mentioned earlier, I've been around long enough to have one of these arguments and walk out and be certain that I was going to lose and then prevailed. And I've had other arguments where I walked out certain I was going to prevail and lose. So I can't give you a prediction. I will say this: it's extremely difficult to write an opinion that the state wants written that says the 26th Amendment is just surplusage. It's language in the Constitution that has no additional meaning outside of the existing provisions. And it doesn't comport with the text, which, is the judicial trend at this moment in time, is we follow the text wherever it takes us. So I think it's very hard to write an opinion that rules for the state. But again, I can't give you a prediction on how this sorts out in the end.
Great. Chad, do you have any final thoughts?
I don't think so. Thanks for taking an interest in this. It's critically important stuff.
Yeah, thank you guys all for joining us today. If you have any more questions for Chad, please contact me at abhi@txdemocrats.org. Again, that's abhi@txdemocrats.org, and I'll set you up with Chad to answer those questions. If you want to also talk about our Texas Voter Registration Week, contact me as well. Again, we're trying to contact 1 million voters in hopes of getting them registered this entire week, which is a game changer in Texas, and it could be the difference between winning and losing. So thank you guys all for joining us, and have a great rest of your afternoon.